a nutshell, hot and getting hotter.
Yeah.
Right?
Yeah, it's about to get super hot. We have 31 alert days in effect for Tuesday and Wednesday due to our heat index values. They could get up to 110 degrees. Rain chances will start to increase as we go into the weekend due to our first cold front of the summer, but that won't knock our temperatures much. The humidity also will not let us feel any relief from the warm temperatures. Sorry to bust it up.
Yeah, we'll just have to hold on. Thanks, lady. Thanks for watching WAAY 31 News at 10. Stay up to date at our website, waaytv.com. Have a great night, but stick around right here. LawCall is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Heath Brooks, going to be sitting in for Sharon Doviet tonight. And tonight our topic is Ask Us Anything. Call or text us with your questions, 256-536-0077, or email us your questions, lawcall@waaytv.com. And that means tonight, if you're dealing with any kind of legal problem, that's a contract dispute, that's a personal injury, maybe it's a family matter or an estate issue, call us. We are open. We'll tell you what our opinions are. Maybe if you've got an issue about what it's going to cost, we'll help you there too. We're literally here to ask anything, aren't we?
You know, like we used to call it stump the chump, and whatever, whether it be car wreck, summertime injuries, you know, she mentioned it's 110 next week. We've been dealing with a lot of summertime stuff, boat wrecks, you know, sadly kids getting injured in pools,
That's
unintended, you know, things like that. So be brave, give us a call, 536-0077, or text us, same number. You know, Heath, we deal mostly with, you know, litigation stuff, whether it be medical malpractice, workers' compensation, premises liability, which you just had a big win in last week, well done, and general injuries.
That's right.
I tell people we don't do criminal work, but for family and friends.
That's right.
You know, most lawyers, a lot of lawyers sign up for the indigent list defense in the beginning of their careers, and some stay with that to get experience and represent. So we have a little bit of experience with criminal law, but every now and then we have great guests to come and help us answer those questions.
Tonight we'll answer all those questions. But before we get into answering your questions, we have a video for tonight.
So, drive-through, Pat, they said was the title.
Oh. Have you ever heard of a car driving through a vet's office?
Yeah, so, wow, you know, so in the notes we got from this video, Heath, it mentioned there was some sort of medical emergency from the driver of this vehicle.
Oh, yeah.
You know, it's, you know, shocking to see. You know, the driver obviously is not allowed to do it. So driver, you know, failed to either maintain the proper lookout, obviously failed to, you know, keep a safe distance, failed to control the vehicle, and the driver's liable for all types of things. We talk about, you know, as you can see, we don't know if there's any injuries yet. You got damage to the vet's office. There may be injuries involved. That driver and that driver's insurance carrier, if he or she had that type of coverage, is liable for the damage to the vet's office up to their policy limits. So let's just talk about the property damage first. You got damage, let's say the contractor comes in and says it's going to cost $40,000 to repair that building. Let's say the insurance company, the driver of that car only has $25,000 worth of property damage coverage. Where do they go and get that? The premises owner can make a claim against the driver, but again, the driver's insurance is only responsible up to their applicable policy limits, which let's assume it's $25,000. If it goes over that, there's a potential to where the property owner has coverage that will come in and pay excess over that amount, or you can have a judgment against that particular driver for the excess. The question is it recoverable, i.e. can the driver declare bankruptcy on that? Was it an intentional situation, or was it a medical emergency? If it was a medical emergency and the driver could not or should not have known of his or her medical emergency, then there will be no liability, and that would fall on the insurance carrier of the premises. Now, of the injury case, there's a part of that as well.
Well, you know, we've had this issue before, and a lot of times when you're dealing with a sudden medical emergency can be anything. Maybe that can be a that can be a stroke, a heart attack, or anything like that. But if you know about your medical emergency, and I should say, if you have a sudden medical emergency under Alabama law, you are not responsible if you cause an injury with your vehicle or if you cause property damage. But if you knew or should have known that you could have a medical emergency, in other words, you've had a seizure before, or you have had some sort of issue that should have prevented you from driving, then you can be responsible for what that conduct causes in terms of an injury and property damage as well.
And how that plays out, there was a case a few years ago tried, in North Alabama, and basically the elderly defendant driver had a seizure on a Monday, wrecked his vehicle. That Thursday, got another vehicle, had another seizure, and then injured someone on Saturday. So under those circumstances, the driver knew there was an issue, and I get it. You don't want to take mom or dad's keys, or you don't want to give up your freedom, but you have an obligation to the community and those other folks using the roadway. And the jury was pretty harsh with that particular defendant because it was so blatant and he just didn't care.
Yeah.
And so that's when it really you're really not only your insurance is liable, but you're personally liable as well.
That's true. Well, we got callers waiting. Sandra, what's your question
Hi, this is
tonight?
Sandra.
Hey, Sandra.
Hey, Sandra.
Hi, so I recently filed and my divorce was legalized, and I am currently pregnant. In our divorce decree, it does mention the child as baby boy and then our married last name. But I have sole physical custody and we have joint legal. My question is, once I give birth, am I legally obligated to give the baby the father's last name?
That's the only child, right?
Correct.
So you guys have joint legal and you have primary custody, correct?
Correct.
So I guess if it's pregnant, if she's pregnant, Heath,
Well, here's
the divorce decree names the unborn child, right?
That's right. Well, and I think that Sandra, it's going to come down to if you have legal, full, and sole custody of the child. Now, physical custody is one thing, but if you have legal, full custody, meaning the father doesn't have any parental rights at all, well, then you would have the ability to name the child with whatever last name you want to name. In other words, you don't have to follow what's called patrilineal descent, which is taking the father's last name. If you have physical custody, there could be an issue. In other words, the father could challenge, what the last name of the child is going to be. But that's something that you would really, you probably want to contact a family law attorney about to just make sure you're taking the appropriate steps to ensure that you're, one, following the divorce decree and not running afoul of that, but number two, that your custody is broad enough to be able to allow you to drive the decision making on the last name of your child. And we do have a text question.
Caller or no?
Another text question.
Okay. All right, so commercial driver hit my vehicle, totaled my Mercedes-Benz. The driver of the vehicle was not covered, and my insurance, okay. The vehicle was at a car garage. It costs $250 a day. There's been 3 days I can't pay it. Can I sue the company that hit my vehicle?
So the commercial driver hits your vehicle, totals your car, and then the driver of that vehicle was not covered.
So I'm reading it that the driver of, you're borrowing my car. You're not on my insurance. 18-wheeler hits you, right, in my vehicle. If I give you permission, you didn't steal the vehicle, then Heath has permission. He's a permissive user. He is covered under my insurance. Now, the 18-wheeler company will be liable for the damage before it even gets to that. So that's not a get-out-of-jail-free card just because the driver of the plaintiff's vehicle was not listed on the policy. If there's a permissive user situation such as this, then if it comes to that, then Mr. Brooks would be covered if he was driving my vehicle. The first claim would be against the 18-wheeler driver, the company that he or she was working for, and if there's not coverage, then you've got collision and comprehensive to talk about property damage. On the personal injury side, you need under or uninsured motorist care. So I'd look to the 18-wheeler carrier and driver first, then go to your own carrier, and your own carrier you would not be excluded because of a permissive use situation, just as we talked about.
Or non-permissive. I mean, if the person driving your vehicle wasn't supposed to be driving your vehicle and it gets hit by a commercial vehicle and that person did no wrong, then the commercial vehicle is still going to be responsible for covering the damage to the property. So yeah, you can sue the commercial company and try to get your property damage back.
And let's say I let you buy my car, you make a mistake and hit someone, you would be covered.
Right.
Yes?
Correct.
Okay. You steal my car and then you hit somebody and you're sued. My insurance company will not cover you under those circumstances.
That's right. That's right. We have callers waiting. Dan, what's your question, Dan?
Yes, sir. Thank you. My question is, when you have a civil judgment by a person that was found guilty of charges in the county, what's the best way of going about collecting your civil judgment when they aren't paying, well, when they're off probation and they are now not paying any restitution because they were paying the minimum to the circuit clerk for $50 or $30 or whatever they got when you were able to get so?
Dan, how did you get the civil judgment? What was that for?
It was a car wreck.
Okay. So you got a civil judgment, and now you're looking to see how it can be paid. You know, there's a couple of different solutions here. The first, of course, is if somebody's not paying a civil judgment, you have to do what's called execute on that judgment. And there's a number of ways you can do that, but it's all the requirement of filing with the court. And generally, it's generally going to be the circuit court. It could be the district court, depending upon where you got the judgment. But you can seek to garnish their wages, to garnish the person who owes you money wages, if that person has property. What you can do is you can put a lien against their property. So you may not be able to immediately execute on their property, but if they try to sell that property, they got to pay your debt before they can sell it. The other thing is you can potentially get the court to execute an auction to sell the property if that person owns it in order to pay back your judgment. But all of those things require you to file a judgment with the court, or you file your action with the court to be able to execute on that amount.
Let me ask you this. Was he found guilty in a criminal case as well?
Yes.
Okay. So there's a couple different judgments. So let's say he's found guilty in the criminal case, and he's ordered by the judge or jury basically that he has to pay victims' compensation. And that's paid to the state. There's a victims' compensation fund out there, and usually it does not fully compensate victims, but it's something to at least help them out to try and get them back to where they were. Victims' compensation is different than a civil judgment. So the victims' compensation would be the criminal penalties that the defendant has to pay, court fees, victims' compensation units, any type of fees the judge puts on for that particular criminal conviction. So that's one thing, and you get that from the state as a victim. Under the civil law, if you get a judgment, just like he says, that's good for 10 years, arguably longer if it's refiled with the probate court. But again, the tricky part is how do you recover it if they're not paying? You mentioned they're not on probation anymore, so there's no real leverage there, and you're limited to those things if it's a civil. If it's victims' compensation, you can contact the state, and maybe if there's probation, they can revoke probation in those circumstances. So you have a couple different avenues to go to look at.
They're telling us we need to take a break. We'll be right back to answer more of your questions.
Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
And we're here tonight answering all your questions. I'm here with my partner, Will League, and we have callers waiting. Aubrey, what's your question?
Yeah, it's kind of a long story, I guess, but I'm 84 years old, and the probate judge and the DHR sold my house without asking me, told me to live in assisted living. They didn't just tell me, they carried me down here. I did not want to go there. I mean, it's a good place, but I'd rather be at home, you know. I was by myself, but I had a woman coming in to clean the house and do my laundry twice a week. No problem. I mean, I can do everything I need to do without any help, except for a few things like cleaning the house and doing the laundry. I do have a little problem getting around, but I still have my mind.
Aubrey, you sound good. I'll go ahead and tell you.
Yeah.
Okay. Thank you. But I tell you what, let me go back to the beginning now. The reason they did that, I was scammed online. I guess you've heard of people getting scammed online, and I was one of the few people that didn't have enough sense to keep from getting scammed, I guess. But I was investing money with these people that were going to make me a millionaire, you know, and I was throwing away money to them and not getting anything back. And actually, I was helping a few people out that said they were starving. Now, I don't know if they were or not.
How DHR get notice that you either got scammed or may not be able to take care of yourself or whatever issue they had?
Well, I don't know. I mean, the fact that I was spending money that I shouldn't have been spending is the only thing that I know of that they had against me.
Was there a caseworker? Do you have any children that are helping you out? And that's one question. And second was, did DHR come and force you out of your home? Did you get a letter? How were you? Was there a hearing? Anything like that?
Well, I guess my son was. I don't remember what the title is, but he was kind of like a probate. You know, kind of overseeing me.
Was he your power of attorney, Aubrey?
What?
Did he have your power of attorney?
Actually, he did not, but it was sort of like that, but the court called it something else. I don't remember exactly what it was, but anyway, shoot, what was it? I just, you know, when the house money, sale of the house money runs out, I'll have to be put in a nursing home because my Social Security is not enough to pay for this rent down here. It's over $3,000 a month. You know, and I could be living at home without paying any rent. My house is paid for. Now, my son sold this house, my house, to his brother-in-law, which smells kind of bad. His brother-in-law does that for a living, flips houses, you know. And so he told him he was going to fix it up to be a more modern house. It was built in 60 or 61. You know, I mean, it was fine as far as I was concerned, the way it was. Anyway, well, he didn't do any of that, but he sold it right quick, made a big profit on it, I'm sure. And now the second guy is headed up for sale, and I don't know whether he sold it yet or not. But
well, Aubrey, let me back up. Now you have rights, okay? Just because you can't get around, that doesn't mean that you're allowed to be pushed out of your house, okay? So some of the instruments that you sign for someone to make decisions for you, health care advance directive, to where, God forbid, you're in an incapacitated state, then that person can make medical decisions for you. A power of attorney, and that if you sign a power of attorney, your son has the ability and permission to sell that house, but it doesn't usurp. You can refuse to sign the paperwork. You have a personal representative that's in your will, but that personal representative does not have any power until the probate court appoints that person upon your death as your personal representative. And so the power of attorney is what's concerning me. But again, if you are incapacitated, if you're unable to take care of yourself, that's one thing, and maybe there's a guardian to look over you and a conservator to look over any assets that you have. I get it, there was a scam for the Nigerian prince or whatever was going on, but there has to be a hearing to determine whether or not you're unable to take care of yourself. And so if you think you can be at home and your son's done something, I suggest you talk to a probate attorney, because you are not without rights. Even though you have signed a power of attorney, you still can deny that sale by not signing the paperwork. Now, it sounds like it's already happened. So I would sit down with a probate attorney in your county and challenge that and see where you are. How long ago did the house sell?
How long has it been since it was sold?
Yes, sir.
I'm not sure. Well, the first time it was sold was about 3 months ago, I guess.
Okay. Now, Heath, the statute of limitations on fraud. Let's assume there was some ill intent. Don't know if there was, but let's say his son was hooking up with his brother-in-law and they split the profits. That's fraud, right?
That's right. 2 years on fraud. However, you can have a situation where you're not able to discover the fraud. It's from when it's discovered. You got 2 years from the date that the fraud is discovered. And it could be a situation here that you need to look into. I mean, even if the home is sold and it's sold out from under you and you didn't have any reason to believe it was going to be sold, or maybe it was sold because the court had given authority to your guardian. The house still has to be sold in good faith, and your guardian would have a fiduciary responsibility. That means he has to do right by you to sell the house for the fair market value.
And that's exactly right. I mean, that is the case. Now, to be fair, it's not unusual for people with advanced age to think the kids are stealing from them or something. I'm not a doctor. You know, Aubrey, you sound good to me. I haven't seen your medical records. Maybe all this is in your head. Maybe it's really happening. I do not know. But you need to talk to an attorney, get yourself vetted, have an independent medical exam to see if you can make those decisions, and you can challenge that to try and get back in your home. And if it's already sold and there's been fraud involved, then there's an action to be taken for that. So we encourage you to sit down and talk with someone, because it sounds like, your folks aren't treating you well. But again, we need to look at more documents.
You got callers waiting. Andy, what's your question?
Yeah, I've been paying hurricane insurance to an insurance company I've been with for about 30 years. And they just tacked it on there. They didn't tell me this went on. When I got papers, it had been tacked on to my insurance. And actually, I don't know how long I've been paying it.
Now you're in Hartselle? It's hurricane?
And they charged me $32 a month for hurricane insurance, and I don't live in no hurricane-prone area.
Well, first thing, Andy, I guess you need to do is go ahead and cancel that insurance company, go with somebody else. And the question is, can you get your money back after you've been charged this $32 a month for however long, something that you didn't pay for? This is the answer to that is maybe. You know, if it's a situation where they slipped it in at some point in time, you can get that information from your insurance company, and you can see how long you've been charging it, and you can ask them for a refund to get your money back. Now, would it be good to go all the way to take it to court? Maybe not. But you can try to get your money back. But I would certainly make sure that you look very closely at your insurance policy to make sure they're not charging you for anything else.
That's right.
We're going to take a break. We'll be right back answering more of your questions. If you didn't get your questions answered, you could always contact Will League or Heath Brooks at the law firm of Timberlake, League & Brooks. We can be reached at 256-536-0770 or www.law-injury.com.
And even though she's not here tonight, we'll let you know Sharon Dovey at Family Law Attorney, Huntsville, all over, 539-7337, SharonFamilyLaw.com. You know, Heath, a little comment on Aubrey. We handle nursing home abuse cases quite a bit. There's arbitration agreements, there's power of attorneys involved, so make sure you've got your documents straight, either for yourself, if you have a power of attorney, which somebody may have, you know, we talked about Aubrey's case, but you want to have those documents just in case, you know, in case you need them for anything like that. We handle a lot of nursing home abuse cases, and it's not uncommon for those documents to be a mess or not have them at all.
And check with your parents, check with your older folks, make sure they're not getting scammed, because that happens, and it happens to a lot of folks out there.
It sure does. It sure does. Nice.